let's say I am a parent of a disabled child,
Hmm.
and my disabled child does not have assets. Maybe they're on Medicaid, maybe I support them, but they don't have their own money. I might draft a will, and in my will, give my two healthy kids their distribution outright. And then my disabled child, I, in my will, might create a special needs trust using my money for that disabled child. Because that money never belonged to that disabled child. It was my
Right.
money, and I'm putting it in a trust for that child. That would allow that child to continue accessing Medicaid, continue accessing long-term care, continuing accessing Social Security without having to spend that money down.
Welcome to the Answers for Elders radio show.
And welcome back, everyone, to Answers for Elders Radio Network, heard across the USA. And I am here with Andrea Lee, who is an estate planning and elder law attorney for Legacy Estate Planning in Bellevue, Washington. You are fully licensed in the state of Washington, working with families all across the state. But a lot of this information that Andrea is sharing is federal information. So just because you're in Washington State, Andrea, a lot of this stuff that you're talking about, these are federal programs. Is that correct? I just want to verify.
Yeah, so special needs trusts are based on federal law. Each
Mm-hmm.
state interprets those laws, and so the way the state of Washington might treat a special needs trust might be different than the state of South Carolina. And
Right.
so even though and the Department of Social and Health Services, they all kind of interpret trusts slightly differently. They impose their own rules, their own regulations, but the general ideas kind of apply overall to special needs trusts. But like I said, if you're in the state of Washington or you're outside of the state of Washington, this is for general educational purposes. And really, any individual who is facing incapacity, who has a spouse who's facing incapacity, anybody who's alive should really sit down with a estate planning and elder law attorney and formulate a plan that best fits their individual needs.
Absolutely.
And that's
Absolutely.
it.
And what you're saying is so true because we just ended the last segment talking about one of the biggest mistakes people make is they don't spend a few $1,000s to potentially save their life savings, all their assets, all the things that they've accumulated through their lives. And this is the thing that just blows me away, that these things, they think that they have everything set up and they may not, especially
No.
once they hit over 65 or once someone in their family has an illness or anything like that. Something can change just on a dime, and if you don't have those kind of pieces in place, it can be really devastating.
Absolutely. I mean, terrible things happen to young people. Young people
Hmm.
are in car accidents, they become ill,
Yeah.
they need estate plans. But the older you get, the more likely you are to face a crisis.
Yeah.
So every year that passes that someone has not created a plan is just increasing that gambling. You're
Hmm.
increasing that gamble that nothing's going to happen to you, that you're going to stay healthy and alive forever, which we
Hmm.
know is not true. And that's
Right.
impossible for all of us.
Right. Right.
But today, I was really hoping to talk a little bit about third-party special needs trusts.
I was just going to get to that topic. So let's talk about we covered in our first segment basically the first party
Mhm.
special needs trust. So we're going to talk a little bit now in this segment about third party special needs trusts.
Right.
Define the difference again, if you don't mind, just so if somebody's picking us up in this segment.
Yeah. So a first-party special needs trust is a special needs trust created using an applicant or a beneficiary's own assets.
Hmm.
So if an individual, for example, has some money that they earned before they became disabled,
Hmm.
or maybe they were already on Medicaid, they were already on Social Security, and their great aunt decided to leave them a couple $100,000, but oh my goodness, as soon as they get that money, they'll lose all their benefits.
Hmm.
So that money belongs to the individual who's incapacitated.
Right.
Since it's their money, the only option is typically a first party special needs trust that they would create themselves. But there are limitations on that trust. And if somebody wants to learn more about it, they should go back and listen to the first podcast, because I don't want to use this one
Absolutely.
talking about that first party special needs trust. A third party special needs trust is a type of special needs trust. And I do want to say that some people call special needs trusts supplemental needs trusts, and they're the same thing overall. So the term special needs trust and supplemental needs trust are fairly interchangeable. Okay?
Okay.
So a third party special needs trust is when the assets that are put into that trust, and the trust is created by someone who is not the incapacitated individual.
Got it.
So a good example of that would be, let's say I am a parent of a disabled child, and my disabled child does not have assets. Maybe they're on Medicaid, maybe I support them, but they don't have their own money. I might draft a will, and in my will, give my two healthy kids their distribution outright. And then my disabled child, in my will, might create a special needs trust using my money for that disabled child. Because that money never belonged to that disabled child. It was my money, and I'm putting it in a trust for that child. That would allow that child to continue accessing Medicaid, continue accessing long-term care, continuing accessing Social Security without having to spend that money down.
Interesting.
Now, that's one use of the special needs trust, but as an elder law attorney, we most frequently use them when we have a married couple, and sometimes we even use them when they're both healthy. But we almost always use them if we have a married couple and one spouse is incapacitated.
Yeah.
So for example, I don't know if you remember, Suzanne, but my mom was diagnosed with dementia in 2014. My dad was very healthy. And when my mom was diagnosed with dementia, we faced the reality that, you know, as long as my dad was alive, we could preserve. As an elder law attorney, I could use my resources and my knowledge and my skills to help preserve most of my parents' money. And I could do that by making sure my parents have a valid estate plan, transferring assets to my dad, moving some things around, maybe just creating a great plan to preserve assets.
Right.
But even though my mom was the one with dementia, there was the possibility that my dad could die first. I mean, he could have a stroke, he could be in a car accident. So when we have a married couple, what we frequently will do is we will impoverish the incapacitated spouse, enrich the healthy spouse, and then in that healthy spouse's will, we would create a special needs trust. So in my parents' situation, if my dad happened to have died first, the house that he lived in would go into that trust. His retirement accounts would go into that trust. Their monies would go into that trust so that my mom could receive long-term care benefits, and all that money could be preserved and help supplement what Medicaid does not cover. So that's a type of special needs trust that can be used by married couples to ensure they never have to spend all of their money down in order to qualify or to keep a spouse on Medicaid benefits or on other Social Security type of benefits.
So in that case, I can totally see that this is a standard thing, because with a lot of individuals out there, they don't realize that there's ways that they can protect their assets through and really the home that they live in through this type of a program. And that's the thing that's so powerful.
Absolutely. Some of the most unfortunate circumstances that I see in my practice are people will come to me, especially a married couple, and they might tell me a story about, oh, my husband was diagnosed with dementia 5 years ago, 6 years ago. I've been taking care of him at home. I met with a social worker, and the social worker told me, oh, once you have $57,000 in the bank, then you can get your husband on Medicaid. And that's kind of the letter of the law, but there are so many exceptions. There are so many ways to work
Yeah,
around that,
that's
that
right.
those clients have relied on the word of that social worker and relied on that advice. And they have missed out on opportunities to save hundreds of thousands of dollars to
Mhm.
ensure that neither spouse ever becomes completely destitute.
Sure, sure. That makes sense. And then obviously, um, the moral of the story is if you get a diagnosis like this, the first thing you should do is, even if you have an estate planning, you should probably go visit your attorney, estate planning attorney, if you already have one, or if you don't, really make a beeline to figure out how you're going to financially preserve as much as you can of your assets, as well as get the proper care that they need and resources.
Absolutely. So as soon as someone does have some type of a diagnosis, becomes incapacitated or ill, they should reach out. And I'm gonna reach out to your estate planning attorney. I'm gonna up you a little bit and say you should in fact reach out to an elder law attorney. And
Mm-hmm.
that's because elder law is really a very specific area of the law.
Right,
And
right.
some estate planning attorneys are well versed on elder law issues, but some estate planning attorneys
Mhm.
simply are not. So
Right,
if you, your child, your spouse are facing incapacity specifically, then an elder law attorney is really the way to go.
right,
Okay.
right, right.
Now, so that testamentary special needs trust, that third party special needs trust, we so frequently will prepare and create in a married spouse's will, but there are other ways that they can be created and that can be used in very creative manners to preserve assets on behalf of an individual who has some type of a diagnosis or incapacity. Um,
Mm-hmm.
a child can create a special needs trust on behalf of a parent or a cousin or a friend, or
Mm-hmm.
I have clients like you mentioned earlier who might have early onset dementia or Alzheimer's disease, and their parents might still be alive. And
Yeah,
the worst thing that they could do is leave a chunk of money to their child who
right.
has dementia or Alzheimer's disease. So that use of that third party special needs trust is one that is completely undervalued, and people
Mhm.
fail to pursue it as a legitimate and fantastic planning tool.
Yeah, yeah. And to just think about when you're talking about elder law and special needs, I don't, sadly, I don't think that the majority of the population really understands what an elder law attorney does.
Mhm.
And really, it's about protecting the asset in many cases of a senior, someone that may be low income or fixed income or anything like that, to get as much money and care coming to them as possible. I mean, I think, isn't that the ultimate goal of an elder law attorney?
I
There's
think,
more than that, I know,
I mean,
but
there's a lot to it, but I would say the ultimate goal, like you said, the ultimate goal of most elder law attorneys is ensuring the aged individual is receiving the best care available to them
Mhm.
while also preserving their assets if possible.
Right, right.
And that becomes even more important when we have a married couple.
Mhm.
Because it's so unfortunate when you have a married couple who worked hard their whole lives, saved their money so they could have an enjoyable retirement. And then
Mhm.
they are, unfortunately, one spouse is diagnosed with some terrible illness or disease or chronic
Yeah.
disease where we know they're likely to decline. And then they're facing the possibility of and the fear of losing their home, losing all of those assets they've worked hard for their whole lives. Those
Mhm.
elder law attorneys, we want to protect the incapacitated person, but we also want to make sure that their spouse, if they have one, has adequate resources to last their lifetime.
Mhm. Mhm. Well, that's very good advice, Andrea. And you and I, we're going to be right back right after this. Did you know that you can discover hundreds of podcasts in our library on senior care? So visit our website and discover our decision guides that will help you also navigate decision making. Find us at answersforelders.com.